Chair Prozanski, Vice Chair Thatcher, members of the committee, my name is Mike Schmidt. I'm the District Attorney of Multnomah County. I come to you before you to support Senate Bill 819. As you've heard from Senators Lieber and others, every prosecutor has a case that sticks with them, and it's the case that you remember because not because everything went right, but because at some point it didn't. You could see the result you reached and how you got there, but you could also see that despite your honest best efforts, something just didn't fit, and it might not even have been clear to you until later. I immediately remember the case of a young man who at a very young age walked into a shoe store, flashed a real gun, and demanded a pair of sneakers. He did it on camera, and he was still wearing the sneakers the next day when police went to his house to arrest him. The crime was robbery in the first degree involving a firearm, a mandatory minimum sentence. He went off to the custody of the Oregon Youth Authority, where he excelled. He was committed to his rehabilitation, took every program offered, and invested in real-life, practical job skills that would position him for success after he left custody. The only problem was his sentence was still too long. It was long enough that he would spend the last few months of his incarceration at the Oregon Department of Corrections. A juvenile who ages into the Department of Corrections goes from being a leader and a mentor surrounded by his peers to the youngest, most vulnerable member of a population dominated by adults who are far older and far more established in their criminality. Less than a year in adult custody wouldn't be enough time to engage in any programs or take any meaningful steps towards rehabilitation within that system, but it's certainly enough time to undo much of the progress that young man had already made. In California and Washington, a prosecutor identifies a rare or deserving case like this one has the ability to petition the sentencing court to reconsider whether the sentence originally imposed still serves the interests of justice. But the ultimate decision to depart or not is still made by the judge, using clearly listed statutory factors designed to guarantee that any revision of the sentence really is the right one. And that's why I'm supporting Senate Bill 819. Senate Bill 819 is based off of Washington Senate's Bill 6164, which passed overwhelmingly with bipartisan support. And you've heard from DA Reisig how these concepts work on the ground in California, another state with the same model. And I've similarly checked in with my colleagues in Washington state. I'm confident that it'll work in Oregon as well. One of the most important features of this bill is that it provides district attorneys with the ability to use the resentencing mechanism within their own discretion. And it allows each DA to develop a policy which fits the priorities and resource availability of their own counties and is responsive to their constituents. This bill simply creates an option for prosecutors. I had one concern. While Senate Bill 819 is written very much like Washington's law, I wanted Oregon's version to be as protective of victims as possible. And so I'd like to thank the Oregon Sexual Assault Task Force, the Oregon Law Center, among others, not just for their support of the bill, but also for work to help craft amendments that will make this bill even better by guaranteeing victims to get the opportunity to receive the petition in a trauma-informed context and with the assistance of a victim advocate, and by instructing judges that they should explicitly consider the safety of victims in deciding whether to grant a petition. These amendments are still being drafted, but I want to recommend them for passage when they're ready. Senate Bill 819 is an established model drawn from the expertise of other states, and it makes sense for Oregon. As prosecutors, we work hard to uphold fairness and justice in all that we do, but across tens of thousands of cases, even the smallest margin of error can lead to justice not being served. So with that, I urge your passage of Senate Bill 819.